Good evening. This is Rahul. Every Tuesday, we do bring in immigration updates from Houston, Texas, from 5 p.m. 6 to 6 p.m. Central Time. We take live questions from 5 p.m. to 6 p.m. Central Time. Along with me is my business partner, Emily Riemann. Emily, what do we have today to discuss?
Well, last week, the H-1B lottery, the electronic registration window ended. So we'll talk about where we go from here, what to expect, and what our guesses are for how many applications USCIS may have received for this year with all of the changes in place. And then recurring problem that we're having, there are just no H-1B or H-4 visa interview slots available in India. It's been going on for 3 months now. We had all of those cancellations over the holidays. Those people were rescheduled into 2026 and even 2027, but new people can't make appointments. Is there a light at the end of the tunnel? Anything moving forward or progressing in a positive way for that? We'll talk about what to do when your final action date is current and your 485 is pending. And last, we'll talk about H4 EAD delays. We're kind of in a Groundhog Day situation where we're back to where we were in 2020 and up into 2022 with these H4 EAD delays. Can you keep working or not? And what can you do if your EAD is expiring soon?
The first thing, what is your guess? I would say last year there were 340,000 H-1Bs that were being done in fiscal year 2026. Into the fiscal year 2025, it was 470,000. So and the previous year, in fiscal year 2024, it was 758,000. So from fiscal year 2024 to 25, it went down very significantly. And from fiscal year 2025 to fiscal year 2026, it went down significantly, almost more than 100,000. So every year I see that from fiscal year 2024 to fiscal year 2025, it went down by more than 250. And from fiscal year 2025 to 2026, it went down more than 100,000 though. And right now we have this $100,000 fees for all those H-1Bs if a company wants to file. And if a company gets selected for the H-1B, if the people are outside the country and they want to file the H-1B, we have $100,000 fees. And there are some exceptions, but we haven't heard anybody giving exception for the $100,000 fees. So what is your expectation in light of all these things, Emily?
Yeah, so we know that in prior years, about 46% of the H-1Bs approved in the cap are for consular processing. So we can assume that some of those people are actually eligible for a change of status and are in the US, but those that are actually consular processing probably did not get registered this year. So based on that, my guess is somewhere around 250,000 because I think that companies are unlikely to register for anyone who's outside the US. I don't think the change to the wage-based lottery really changed much in terms of how many registrations there were. We'll probably see some differences in how the selections are based on that wage-based lottery. But in terms of actual registrations, of course, USCIS has not announced it yet, but I'm going with 250,000 as my guess.
I'm going with 200,000, Emily. So let's bet who wins it, and then you have to pay me $10 if I win, and you win, I'll pay you $5.
Not sure how that works, but okay.
Let's get into the H-1B and H-4 stamping, Emily. There is no visa available right now, and there are no visas available until March of 2027. There is, and we don't know if there's going to be any visa availability for the H-1B and H-4s. Of course, there are visa appointments available for F-1, and there are visa appointments available for the B-2s, but there are no visa appointments available for H-1B and H-4. What do you see anything, Emily? What is going on? What is the policy or any changes that may be coming in? And as you know, that the third country, we can't apply in a third country national where we can't go to Vietnam or Dubai or not Dubai. I'm sorry, not in Dubai, but any other consulates. You cannot apply right now like the way it used to be before.
Yeah, I think the number one issue that's creating this was the elimination of Dropbox. So now everybody who needs to travel and go for stamping has to be interviewed. And number two, the social media vetting that they implemented in the winter of 2026, that is supposedly limiting the number of appointments that they can conduct in any given day because it takes them time to go through all the social media. Now, how much that's true, I don't know, but I think that's their reasoning behind it. The downside is I don't see anyone urging the Department of State to improve the situation. Typically, we would, hear from members of Congress urging the Department of State, hey, we need to open up more visa appointments. This is hurting business. This is hurting people's ability to travel. And I'm not hearing anything about that right now. There does not seem to be any kind of concern, which tells me that they're not planning to improve anything because no one seems to be overly worried about it. I think the best thing that could be done right now is for companies to be reaching out to their congressmen and senators, letting them know that this is the problem, that this is impacting their employees and impacting their business. But until someone complains about it and actually gets through to someone who can do something about it, which the only people that can do something about it is State Department, Secretary of State Marco Rubio. Um, there does not seem to be any motivation for them to do it when they keep posting about visas being a privilege, not a right. The privilege is you get to wait for who knows how many months or years just to get an appointment to be able to travel. So again, that reiterates why we said from a year ago that you should not travel during the Trump administration, because there's just no way to get a visa appointment to get your visa to come back on time.
Yeah, and definitely we don't want anybody to travel outside the country. People are saying that they have a lot of emergencies to travel. Emergencies are they're not honoring. There are some emergency things that they're approving, but then they're saying there are no emergency appointments. I mean, what's the purpose for you to grant that saying that you have an emergency, but yet not give an appointment? Definitely, if you guys don't know, Trump administration is anti-immigration. He cannot put some legal restrictions on H-1B. So this is where he's impeding the H-1Bs. The courts have sided with the administration whenever it is outside the border, when it's inside United States. The courts have sided, the courts have opposed the Trump administration and any restrictions on the H-1B. So that's where it seems to be that where the Trump administration has learned from its mistakes and are doing the things in a fashion that is going to hurt us most is when people travel outside the country, when people go outside the country, when people are trying to come from outside the country. Emily, final action date is current for 8.5 is pending. What is the next step that they need to do, Emily?
So I think it depends on what is going on in the case. Has an interview been conducted yet? Is your medical valid? Have you changed jobs? If your medical has expired and you are looking for a way to kind of wake up the case, get their attention and say, hey, my date is current, please approve the 485, submitting your medical proactively before you get a request for evidence asking for it is one way to do that. We call that interfiling. So you can, figure out where your 485 is pending, get your civil surgeon to complete a new medical exam, mail it in the sealed envelope to that location, and include the visa bulletin, include notification that the priority date is current, and ask them to adjudicate as soon as possible. Because there is still a possibility that that medical might not make it into your file, or there might be an RFE issued anyways, we would typically suggest getting two versions of the medical, the same medical, getting duplicates of it, both in the sealed envelope. So two originals, keep one with you in case of an RFE, send one in through interfiling. And that's one way to do it. What are other options that people have in order to try to get their case adjudicated sooner?
When they want to send their medicals to interfile the 485 application to the place where your 485 is pending, I also suggest to request that give them the I-140 approval in EB2, and then give them the visa bulletin page and tell them, look, my priority date is current, please adjudicate my application. If once the priority date becomes current, which is going to be in April 1st, though, if you don't see any action in about 1 week or 2 weeks from the time you send the medical, I strongly suggest you go for the writ of mandamus. You can come to our office you can send an email at info@rnlawgroup.com, and you can file a court litigation. It doesn't cost that much money as you may be thinking. You can always inquire with us personally. Stephen Brown will be happy to tell you the fees and other things in our office. He is our other partner who is in litigation, and he has done multiple of those things. Typically, once he files a court litigation, the USCIS takes about 60 days to respond to that. Past results are not a guarantee for the future one, but I would suggest that, as you know, that the priority dates will move forward, backward, forward, backward, forward, backward. From 2020 onwards, you have been noticing this moving forward, backward. But when the case of me though, I'm been watching the same priority dates since the time I got my green card in 1993. Since the time I got that was in 1993 May, and from June of 2020, 1993, the priority dates backlogged. Before that, the priority date were current for Indian nationals. Luckily, I got my green card in May, and June of 1993. Some of my friends who did not get the green card, they got locked for 3 years. So, and then onwards, I've seen priority dates going backward, forward, going backward, forward, going backward. So, when the priority date is current, though, you should take advantage and take the lawsuit. And people have this question: will the government go against the people? Will it be a black mark? No, it's not. I mean, you have to understand that in the democratic system, going to the courts is the holiest thing that you can do. You are not. This is not a Saddam Hussein or something like that. This is not it. You have seen that every time people have gone to the court. For example, citizenship application, people have gone to the court. They blocked the things. There are a lot of things that you achieve in the courts. Not everything is achievable, but there are some things that are achievable. So we strongly recommend that you take to the court. You can contact at info@rnlawgroup.com. We can send the details of the court litigation for the delay. Now, what is required before you go for court litigation? One, your 485 must be filed. Your final action date must be current, not filing dates. The final action date has to be current. And then I also want, it's not a legal requirement, I also want you to do interfiling the medicals if you have filed the medicals before November 2023. They are no longer valid. Any medicals filed before November 2023 are only valid for 2 years. If they are being filed after November 2023, you don't have to do interfiling of the medicals. So a lot of the people whom I know that filed in 2020 to 2022, they have the medicals expired. So we want them to file the medicals before. Because when we file the court lawsuit, though, the USAs will come and issue an RFE at that point of time to get the medicals. It's going to delay your green card. So we definitely want you to get that thing done. Anything else, Emily?
What about transfer of underlying basis with the April bulletin? EB2's ahead again. Should people be doing that? What if they've already gone from EB3 to EB2 to EB3? Is it worth going back to EB2? Is it creating a problem? Should they try it? Should they submit the supplement, Jay, if they've changed jobs?
The last action rule stands with the immigration, though. What is the latest request that you have done? So let's, for example, a lot of people filed in EB3 in 2020. They converted themselves into EB2 in 2022. If that is what the case is, then you are good. You don't have to do anything. However, there are a lot of people who filed the adjustment of status in EB3, convert into EB2, then later on convert into EB3. So if the last one that you did is EB3, though, it is worth for you to also request USCIS to convert into EB2. Because when we filed the lawsuit, though, and said, hey, this priority date is current, adjudicate the application, the USCIS came back and said, hey, guy, your client requested us to do the application in a different category, which is not current. So we can't give him the green card. So have your client request us to do the particular thing which is current. So we want that action to be done. So there are two ways to get the thing done into EB2 if the last action you did was EB3. You can request your employer to file I-485J supplement with the I-140 of EB2 and request the USCIS to adjudicate the application. You can submit the medicals along with that. That is the best way to approach. That is the best way to approach. If that is not what the employer wants to do, you can self-request the USCIS. Not a very efficient way, but still, it's worth doing it. That, look, my application was filed in EB3. I have an I-140 under EB2. Here is my I-140 approval. And if you have not done the medical, you enclose the medicals and send it to USCIS. Please adjudicate my application. This is required for the USCIS to adjudicate your application. If the medical is expired, they're not going to adjudicate. If the last request, they open the file and they say, hi, Mr. Subbarao has requested for EB3. EB3 is not current. Put out the file. You don't want any excuse for the officer to not approve your case. You want everything to be done. There are multiple cases that they have. If you have everything ready, then they'll be easy to adjudicate. It will become easier for the officer to adjudicate the application. So please request the USCIS official in adjudicating to EB2 if the last request you have done is EB3 and your EB2 is current right now. Now, this can be done by the company, which is the best effective way is 485J supplement and medical. If not, you can do it self. We call as transfer of underlying basis. It's called TUB. That's a short form that people use. You can get it done. We strongly recommend to get it done as soon as possible. I do see some RFEs coming, Emily, for the medicals. I got 5 RFEs for medicals. I told the guys, hey, buy a champagne for you and for me. And yeah, they're very happy. So yeah, so as Emily was suggested that we recommend that you get 2 originals though, because when you do the self-request of the RFE without them asking for an RFE, without USCIS asking for RFE, you send the medicals and you get an RFE for medicals. What are you going to do? Are you going to argue with them? I already sent my medicals. I'm not going to send it. You know what USCIS is going to do? You guessed it right. They're going to deny it. So what the best way is that you get 2 originals, not a copy, 2 originals from the doctor. Send one to the USCIS. The second one, you keep it. When you keep the second one, then if there is any RFE or if there is an interview, if by any chance something happens to the medical, it doesn't reach properly, then you can take it to the USCIS or you can submit to the RFE. Anything else?
All right. Yeah, next topic, H4 EAD delays. So I feel like we're back to where we were in 2020 through 2022. At that time, H4 EAD delays were actually caused by the H4 delays, because if you remember, USCIS issued a requirement that all I-539s, which is the H4 extension application, had to include biometrics fee and be called in for biometrics. And then COVID happened and all the application support centers were closed because no one could physically go in. And so that kind of started this whole delay process. Then we had the Edicuni settlement saying, nope, you can't separate the H4 and the H4 EAD and cause delays. You have to approve them all together if they're filed together. But that settlement agreement ended in January 2025. We were still seeing a lot of decent processing times for the H4 EADs, but now we have a new hurdle, and that's that they're requiring biometrics for the I-765 application, not the I-539. They did not announce this as an added requirement. You don't have to pay a fee for it, but it's based on their December 2025 announcement saying, we can't trust the photos that you submit when you are filing the I-765 for your EAD card. And so therefore, we're going to make you come in and we'll take your picture and we'll use that. So that is now causing the EAD to be separated from the H1 and H4, and the EAD is getting delayed. We're seeing about 6 weeks to just get the appointment for the biometrics. And right now, the processing time that's published for standalone EADs, so this is just the I-765 application where you already have the H4 status valid, is taking 10 months. If you file the H4 and H4 EAD together, the current published processing time is 6 months. And generally, you can only file 6 months in advance. That means you're potentially in trouble with your I-765 not being approved in time. And on top of this, we no longer have the automatic EAD extension rule. That ended in October 2025. So even if your H4 I-94 was still valid, if you filed your I-765 after the date in 2025, I think it was the end of September, you no longer get the 540-day auto extension. That means anybody who's filing an EAD renewal now, if it's not approved before your current EAD expires, you have to stop working in the meantime. Do you have any suggestions or things people can do to try to avoid those delays or get the EAD approved faster?
One is that we recommend suing the government, though. It's EAD delays. Stephen Brown has been very successful in a good thing. Past success is not a guarantee for future thing. So definitely we recommend that once you file the EAD, it crosses 3 months, though, file the lawsuit, though. Because what Emily said is a processing time 6 months is not true at all. And believe me, there are a lot of applicants whose EADs are pending for more than 6 months. There are some cases that have been pending for more than 1 year. So we definitely recommend to file a lawsuit as soon as you cross the 3 months. If you have a job, you think so that if you think so, you have an issue that you're going to lose a job, we strongly recommend to file a lawsuit. Though you can send an email at info@rnlawgroup.com, and then we can give the details. Stephen Brown does conduct frequent Zoom calls separately just for this purposes, and you can attend it so that you can get educated on that. Anything else,
All
Emily?
right. I think we can go to questions. We've had a couple of questions asking for updates on B2 RFEs, people who have filed a change of status to B2 within the 60-day grace period under the policy guidance that was on the USCIS website that's since been archived. We were having those successfully approved for many years, and then all of a sudden in late January started seeing different types of RFEs, started seeing denials of the B2, started seeing RFEs on the change of status back to H-1B when they were previously approving those when the B2 was still pending. So it does not look good for these cases. We have had a couple of approvals, but we've also had a couple of denials. Every single denial I've seen is different based on different grounds of denial. It seems to me that their plan is to deny these cases, to then make the H-1B convert to consular processing because you were not maintaining B2 status at the time of filing. That then triggers the need for you to leave the country and apply for the visa stamp, which then triggers the $100,000 fee. That is their grand scheme. That is what they're wanting to do. As we said at the beginning, with these visa stamping interviews not being available, all of this is a concerted effort on the Trump administration by Stephen Miller to try to get as many people, immigrants, out of the country as possible and not give you a way to come back. So B2, if you are in a job loss situation right now, it is not a viable option if your ultimate goal is to later be able to switch back to H-1B without leaving the country and without triggering the $100,000 fee.
Yes, people have said that some lawyers have advised to file the B2 and they filed, they got an NOID. We take the blame for that too. Our law firm also did advise, along with other law firms also. At that point of time, yes, the USCIS is changing its policy very frequently. This administration is changing its policy very frequently. You have seen that in the past in the visa stampings? They cancel the visa stampings after you outside the country. They introduce $100,000 fees. They have canceled the Dropbox appointment. They've canceled the third country visa appointments that you cannot go to third country nations to get the visas. So there are been policy changes in this administration. They've been very frequently, and almost 99% of those policy changes are detrimental to the non-immigrant people who want to maintain the non-immigrant legally stay in United States. That is how this administration is behaving. And that's also one of the other reasons that you cannot just follow the directions given one time by an immigration lawyer We want you to frequently come to the YouTube channel. We've been having this for past 10 years. So you can get updated what information is going on. I mean, what was being told a month or 2 months ago may not be true right now because administration is changing its policies very frequently. So definitely, what is the solution? We have Emily, me, our entire lawyers group did had many meetings, and we have like what is the strategy to use to respond to the RFE for the B2? What is the strategy to use to respond to the H1B? We have tried many different things. As Emily has pointed out, that yes, we definitely had failures on the B2 to H1B applications. We had some successes. We had some failures at this point of time. It definitely is a risky matter right now. If you have filed a B2 application and you're contemplating to move on to the H1B, is it worth for you to wait for the B2 approval, or is it worth for you to go for the H1B before the B2 approval? There is a lot of risk involved in it. It's definitely a risk point, and what used to be very simple is not anymore simple right now.
Sandy says my I-94 travel history shows a new unknown entry record for January 1st, 2026, and no travel out record. So now there are two entry records, and I've not left or entered the US in years. Had a prudential visa revocation in November 2025. What do I do? Well, there's nothing you can do, and it's nothing to worry about. That travel history is just there in case you need it. It's not relied on for any lawful status purpose. And there's no way to correct it either. So there's not really anything to worry about with it. Just make sure you have proof that you actually were in the US on January 1st, 2026, and did not leave the US at that time. That should cover you in case it ever comes up in the future, but it's very likely won't.
As a H4 EAD holder, can I do prop trading with companies like Apex? I don't know what that is, but it looks like something you're working. Now, I can tell you one thing, that if you are doing a short-term trading in the stock market, we are not stock advisors, guys. Don't take our advice. We're only immigration advisors. Anybody can do stock trading. You don't need to have a work permit to do it. For you to do any work, which I don't know what this prop trading is, but if you have to do some work, then you must have a work permit. In your case, Nandini, you have an H4 EAD, so technically you can work. So we don't see any problem in you working as a trader if you have to. Nothing wrong with it because you're an H4 EAD.
Vishal says I'm on H-1B. My employer has filed an amendment for a location change. What is the timeline for approval for an H-1B amendment? Right now, normal processing time is probably between 6 and 9 months. With an amendment, you can start working at the new location as soon as it's filed. So you don't necessarily need the approval quickly for any reason. So you could let that continue to be processed in regular processing.
Meenakshi Vishwakarma from Facebook has this question. Is it a right time to transfer the H1B right now? Nothing wrong with transferring the H1B. What we would suggest you to be on the safer side, if you're moving from company A to company B, wait until the H1B is approved with company B. File it in premium processing. Once the H1B is approved, voila, you're fine. You're safe for the next 3 years. Hopefully, so by the time the Trump administration will not be there, and hopefully things will turn better at that point of time. So you have passed through the hard time, is what I'm thinking.
Shalu Sen says, is there a social media vetting for H-1B extensions filed from within the country? Technically, no, not in the same way that there is for visa stamping, meaning that you do not have to make your social media public before you file an H-1B extension. There's no requirement for that. However, USCIS has long looked at social media when they are adjudicating all kinds of applications, particularly H-1Bs. They definitely look at LinkedIn to make sure that you are, working where you said you're supposed to be working and all of those sorts of things. So not a particular policy, but yes, they do look at it.
Emily, what do you think of ICE right now doing the TSA job in the airlines, checking the driving license of the people?
I don't know what's happening these days. Yeah, it makes zero sense considering that everybody who buys an airline ticket is paying for TSA security. So why is their funding held up to where they can't get paid? That's silly. For people who are traveling from within the country, if you're undocumented, I would stay away from the airport, even if you were traveling domestically. Otherwise, if you have status, carry your paperwork with you, carry your I-94, carry your passport, just like you normally would. But I don't expect there to be any kind of ICE enforcement activity in most cases at the airports right now.
What if my EAD extension is pending? I don't have any EAD approval. I just have an adjustment of status. What if my H1 extension is pending? It's not approved yet. What is my H4 extension is pending? It's not approved yet. And my I-94 already expired. Do you think so? These buggers will understand what the things are because we know how the ICE people are.
Right. No, they won't. There, you definitely are potentially at risk of being detained until they can figure out what your status is and that you are actually lawfully present. Have not heard of any reports of anyone being detained. I don't know why for a domestic flight they would be looking at your I-94. If you have a driver's license or your ID, that's all they should be looking at to make sure that you
I
are who you said
don't
you are.
have driving license. I'm using my passport only.
Yeah.
I would say at this point of time to stay caution. If you're traveling
Yeah.
in this particular week, we want you to be careful. Probably in about next week, we should be getting a little bit more guidance, is what I would say, Emily.
Yeah, definitely see. I mean, this just started happening yesterday, so no reports of problems yet, but we'll have to see. Nirvana says my 485 EB1A is current. Went from the National Benefit Center to the field office 2 weeks ago. How long can it be before a decision is made? There's no rhyme or reason to it. If that field office is not where you're located, that would suggest they do not intend to interview. And so they're just using that field office because they have people available to adjudicate. And then you're up to, whatever that particular officer's desk looks like. If it's got a stack of files on it and you're at the bottom, it could be months. If you're at the top of the stack, maybe weeks. And there's no requirement for it to go one way or another. If you are being interviewed, because that's your local office, then it's up to when do they have interview slots available. Some high volume locations might have more backlog of trying to get people scheduled for interviews. So it literally could be a few weeks to several months.
Can you transfer back from to H1B from H4 receipt notice? This question is coming from Facebook from Kumar Span. No, we don't have any issues at this point of time transferring from H4 receipt notice. If you had a H1B before, we have not seen any problem right now. We have seen it from B2 to H1B, but not from H4 to H1B at this point of time.
Avin Nash says, I had a 485J approved in 2021, moved to company B in 2023, did not file a supplement J, now returned to the original sponsor. Will they send an RFE for another 485J? Just based on the passage of time, it's very likely because they always want to see if your case has been pending for a long time, that you still have the job offer available. So if the last time they looked at that was in 2021 and now we're in 2026, I would expect to get an RFE for an updated one before they'll approve.
Neelima has this question. What is the timeline for the green card approval interfile to EB2 in 2022? A very interesting question. First is you need to look into your medical. If the medical is not done, they won't approve it. Either they have to wait for an RFE or wait for you to submit the medicals, or they may want you to interview though. We are seeing typically 20% of the cases get interviewed and 80% of the cases get adjudicated. Luckily, right now, even in the Trump administration, that is still true. Nothing has changed anything. How much time is it taking once a day to become current? It may take just 2 weeks for most of the cases if the medicals and everything is ready. And sometimes it may take ever because it depends on the officer. If the officer is very active, he may just open the file. He may have put some alert system. Hey, priority date becomes current. Let me open this file up. Or this guy must be sleeping, won't get the file. So you need to wake that guy, either sending the medicals or sometimes filing in a 485J supplement or filing a lawsuit will wake that guy up on the file. Otherwise, that guy's going to sleep. So normally I'll wait for 2 weeks and see if there is any movement there. Like if they issue an RFP for medical, voila, that's a good news for you. And if they don't, then probably that's the time they should consider suing the government.
Teja says I-485 interview was done in 2022. The date retrogressed and now it's current. Do I need to send in the medical if it's been pre-adjudicated? Yes, because your medical is from 2022, if not earlier, it is expired regardless of whether they've pre-adjudicated your case. It has expired since then, so you do need to get another one. You can either wait for the RFE or send it in yourself through an interfile.
Uma Maheshwar has this question. Where do interfile medicals of primary and dependent applications are different field office though? Typically, the application does not stay in the field office for a long period of time. So it may go back to the National Benefit Center. One of the things what I suggest you to do is file the medicals in both places, field office and National Benefit Center. I mean, that's the best thing that you can do because if I were you, I mean, how much the doctor will charge for getting the second original one? $20, $30. I'll pay for three original copies, send one for the field office, send one for the national office, and keep one with me so that when the RFE comes in, I can respond to the RFE. That's what I'm going to do.
So Rob says, I and my spouse have pending 485s in the EAD. My spouse is on H-1B and lost her original I-797 approval. I do have the scanned copy. Should I apply for the duplicate? Because it may be required for the 485 interview. Well, it shouldn't be required for the 485 interview. They don't need the original of the I-797 approval notice. However, you should apply for it anyways, because if you're out and about on the street and ICE is hanging around, you want to have the original approval notice available.
Are there any downsides of the litigation? A lot of people ask this question though. One thing is that when we file the court litigation, though, it takes about 55 days. They have 60 days to respond, though. They take a long time to respond. Now, if the priority date goes back by the time they respond, their response time, they can just go to the court, hey, dates are not current. We're not going to put the green card. So definitely that's a downside. Now people will ask, will there be any revenge? Will there be anything? Think of this thing, guys. Me, Emily, and Stephen, we are all litigators. We have filed so many cases, especially we have filed thousands and thousands of cases. If this was a dictatorial thing where government will take a revenge, they should first take on Rahul Reddy. They should take on Stephen Brown. They should take on Emily Newman, though. So we are up front of you. We are the persons who are arguing for you. We should be the first one to be gone. So imagine that. So no, it is not the purpose of the government to take revenge if you go to the court. That's not how it works out in the democratic system. And people are very scared about it. And you can come to, Stephen Brown does conduct Zoom calls for it every Tuesday and Thursday. He's conducting on that one. So you can send an email to info@rnlawgroup.com and then we'll send the details to you.
Venkata says, if the H4 EAD is in progress, does it mean that the H4 person should stop working until he or she gets the approval? So if the I-765 is filed after October 30th, 2025, and it's pending, and your EAD expires while it's pending, you have to stop working once your EAD expires and cannot start working again until you get the card in your hand for the renewal.
Do you think so? They will call for another interview? 98% of the time, there are no other interviews, though. There is only very rarely they will have a second interview, though. So I'm not expecting, if you're already been interviewed, very unlikely that it will be interviewed. As I was been telling, in general, 80% of the cases don't get interviewed, they get approved automatically. If there is any criminal record, there is very great chance for getting the interview. That doesn't mean that if somebody is interviewed, there is something wrong. Don't get scared. It's just randomly picked though. So definitely, if there is any criminal arrest record of you, then you should consult an immigration lawyer to make sure how you want to represent yourself in the interview.
Caroline says, I filed for my H4 EAD extension and got an RFE for the photo to be taken at the application support center, but the RFE doesn't have any appointment information. Will I receive another RFE with appointment details? So some cases, most of the cases, they're first sending an RFE letting you know that they're going to schedule an appointment. And then separately, they will send you an actual appointment notice for the biometrics. You'll go get that done, and then you respond back to the RFE showing that you've done the appointment, and then the process will continue from there. In a few cases, we've seen just the biometrics appointment being issued without an RFE, which kind of makes more sense. I don't know why they feel the need to send an RFE to tell us to go to the biometrics, but that's kind of the basic process they're going through right now.
Satish from X has this question though. He filed for 8-5 in 2020. His daughter is locked up in Child Service Protection Act. He has an I-140 approved. Now the daughter turned 23. Can he convert into EB2 at this point of time? First thing, this is a very short time for me to determine if your daughter is being protected by the CSPA. Assuming that your daughter is protected in the EB3, assuming your daughter is protected under EB3 CSPA. Now, if you're going to file under EB2, you need to check whether or not she will be protected under EB2. If she's not protected under EB2, you will get the green card, and this 23-year-old girl will not get the green card. So it may not be advisable for you to do interfiling and request for a EB2. It may not be. So you need to check very closely to see if the daughter is covered in CSP and EB3, which you said she is covered. Is she covered in EB2? If she is not covered in EB2, I will not request a green card for your approval because she's going to get the green card with you along with you in EB3. I will wait for the priority date to become current in EB2, EB3, sorry.
Boss Cam says, is there any downside to filing an I-140 with premium processing compared to regular processing, especially regarding RFEs? If it is a perm-based I-140, so your typical EB2 or EB3, there's no real downside. We're not seeing any more RFEs or less RFEs for premium processing. The one thing to consider is if you have a child that's at risk of aging out, you might want to let the I-140 take longer because that time is subtracted from their age to keep them from aging out a little bit longer. But otherwise, no downside for premium processing for perm-based I-140s. For EB1C, EB1A I-140s, please don't file it in premium processing. We're just getting like 10-page RFEs, just boilerplate, not addressing any of the documents that were submitted. It's a kitchen sink RFE, and so yeah, don't file those in premium processing.
I had an interview, an I-485, received an EAD, AP, but no GC yet. My priority is current. What to do? First thing is that when you do file the medical, that thing, if that has been taken care, sue the USCIS. Simple, sue the USCIS. Okay. One thing, what I noticed in the 485 application, employment based, is it's not as bad as the things in the consulate, guys. It's not, in fact, I have not seen any significant denials, significant RFEs increase in the 485 applications, though. In fact, I've seen a lot more faster adjudication done in the 485 application. There are some 485s that we filed in EB1 category and that were current. They got approved in 2 months. A lot of those things got approved in 2 months. So it's not as bad the situation is in 485. It's just you need to get the attention of the officer. That's the most important thing. Now, of course, we have seen that any time when a person crosses the border, they want to come in We have seen all kinds of harassment. It's like they shoot a bullet in the consulate, you escape it. They shoot a bullet at the port of entry, and everywhere they shoot and you escape, you get into United States. That's how bad situation is. But when it comes to the adjustment of status, the situation is far better. And if you are going to ask me, was it better in Biden administration? Is it better in the Trump administration? I mean, this is the only thing I would say. It's probably better in the Trump administration, the 485 application. They're adjudicating much faster. They're receiving RFEs for the medical much more faster when the priority date becomes current. So that's a good sign. They want to adjudicate, they want to fill the 140,000 plus the leftover green cards for the family based immigration because they're mandated by the government to do so, but mandated by the parliament to do so.
Bibu says, what is the probability seen when all three H1, H4, and H4 EAD are filed together in premium for them to get processed all at the same time? Based on what I'm seeing, H1 and H4s are approved together about 50% of the time. About 50% of the time, the H4 gets approved a couple weeks later. But the EAD now, it's practically 0% that they will be approved together because they have to send the biometrics notice, and that's adding a 6-week delay. They can't get that accomplished during the premium processing timeframe.
My son is Irish born. I am an EB3 and and the son is H4. When he turns 24, does his priority date moves forward? One thing is that there is something called cross-country chargeability. If the child is born in a different country, that is not applicable though. When the spouse is born in a different country, the cross-country chargeability is applicable. But when the child becomes 21 though, and if the child independently have to file a green card, let's say employment based though, then the child will be considered in the Irish quota, not Indian quota. Now, I don't care whether your child holds the Indian passport or Irish passport. Irrespective of it, he will be in the Irish quota, not in India quota, which is very lucky for him though. Now, for those people though, if any of if your wife or husband is born in a different country other than India, now your priority date will be completely different. So if let's say your wife is born in Dubai and she does not hold a UAE passport, she holds the Indian passport from the beginning where she's born in Dubai all the way to right now. Can you come under the UAE quota instead of coming into the Indian quota? Absolutely yes. Wait. She is not the main applicant. The main applicant is me, not her. How can she and I come into that quota? Yes. You, even though you're brought up in India, have an Indian passport, your wife, who's born in UAE, but never had a UAE passport, all along have an Indian passport, will come under the UAE quota. That means in the rest of the world. So it is current. So it's called cross-country chargeability now. If any of you guys have in it, please send an email to us and we will deal with it. You are the lucky.
Anna says, just wondering if USCIS is taking a long time to approve 485 cases, why are they moving the final action dates faster? It's a good question. I think it is because they're taking a long time to approve 485s. They realize that it's going to take them 9 months to be ready to approve a 485. And so 9 months from now, the final action date is likely to be current. And so they need to move that filing date forward now in March so that they can get the case in the pipeline and have it ready to adjudicate by the time the final action date does become current.
Uh, 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 what are the chances for the how long does it take for the H4 receipt notice? It's taking about 3 weeks right now, approximately, for getting the receipt notice. Now, if it takes 4 weeks, don't rush on it. It's not a big deal, guys. It should be okay. My priority date is 2019, and now I moved to a new employer. That employer is not willing to file the I-140. Well, unless the priority date becomes current, which is very highly unlikely if you are an Indian for the 2019 to become current. Now, highly unlikely, but not impossible. um, then there is no need for your current company to file an I-140 immediately right now. You can keep on extending the H-1B since the priority date is not current. You can keep on extending the H-1B with company B, even though company B doesn't have an I-140 approval. You can get the H-4 EAD for your spouse, even though current company B doesn't have an I-140 approval. You can move to company C using I-140 approval with company A, even though company B or company C doesn't have an I-140 approval.
Kartik says, I had filed my 7th year H-1B extension based on my pending perm. Now that my perm is approved, assuming the I-140 gets approved shortly, can I file a new H-1 extension even though my previous H-1 is still pending? It depends on whether the I-94 of your last H-1 has expired or not. If it has not expired, then your employer could withdraw the pending H-1 for a 7th year and instead refile it as a 3-year extension. But if your I-94 is already expired, you need to just wait until this H-1B gets approved and then it'll be valid for 1 year. At the 6-month mark, file the next extension to get the 3-year approval.
Aisha's question, I have a priority date of February 10th, 2015. Wow, that's very close. And can I file two applications, one EB1 capturing the old priority date and EB2 in case the case gets current? Absolutely no problem. Can you use the same, let's say company A has an I-140 in EB2, and now you're filing a EB1 and you want to port the EB2 into EB1 priority date? Absolutely, you can. At the parallel, company B, can it apply for EB2 and port the EB2 of the company A? Absolutely, not a problem, none whatsoever at all. I would do that because I don't want to put all my eggs in one basket of EB1A category, because if that gets rejected, then you will have nothing to rely on when the priority dates move, because it's very close. Yours is February 10th and it's January 15th right now. So definitely I would do both, and you can do both. Perfectly legal and strongly advisable.
Kumar says, can we transfer back to H-1B from a pending H-4 based on the receipt notice? If you had asked me that in January, I'd say yes, no problem. If you asked me that now, I'd say it's probably better to wait for the H-4 approval and then file the change of status back to H-1B. Because if you file the change of status to H-1B right now, you might simply get an RFE saying we need the H-4 approval notice before we'll approve your H-1B. And guess what? You get a limited amount of time to respond back to that RFE. If you don't have the H-4 approved by then, they might convert your case to consular processing because you're not in H-4 status at the time of filing, and that triggers the $100,000 fee. So don't make a $100,000 mistake. Unfortunately, wait for the H-4 to be approved and then file.
My priority date is April 2015 in EB2. My son is turning in college, turning 19 in this June. What is the best way forward for him? But definitely, if the final action date becomes current before he's 21, he's definitely saved. People ask the question, oh, my son has moved to F1 visa. Can I still file the adjustment of status when the priority date becomes current? Absolutely, you can do so. Also, there are some tricky ways we can extend the life of the 21 years of the kid a little bit longer. So that for that, what your company has to be cooperative. But some people, what we suggest is company to withdraw the I-140 and file it again. Why? Just because your lawyers want to make the money? Not exactly true, though. Yes, we do make the money, but that's not the reason why we do that. Let's say your I-140 is approved in 2 weeks. The CSPA, Child Service Protection Act, allows that the longer period the I-140 is pending, that much time will be deducted from the age of the kid for the purpose of the green card. So if your I-140 was pending only for 2 weeks, what we do is that withdraw that I-140, have the company file an I-140 one more time, and let the I-140 take for 1 year. So in that case, your child will become 21, not in when he becomes 21, he becomes 21 when he is 22. That's called Child Service Protection Act. So you can study a little bit about it, and we can extend a little bit time, not much though. Okay. So, and that too, if your company is cooperative.
We are actually doing a webinar tomorrow on the Child Status Protection Act, myself and Stephen Brown. So you can go to our website, rnlawgroup.com, and register for that. It's still open, but the webinar is tomorrow. Rachan says, is it a good time to file for PERM right now? Many RFEs I'm hearing about from my friends while in process. I mean, for a lot of people, you don't have a choice to wait because you've got a 6-year limit for your H-1B, and PERM is taking 2 years to get through. And the more you wait, the more possibility that it could get delayed. They could find qualified applicants. There could be any number of things that could go wrong that make you max out on your H-1B time and not able to extend further. So yes, anytime's a good time to file a PERM application. File it earlier rather than later. Right now, other than processing times, there has not been a major change in how PERMs have been processed. Saw the same thing under the first Trump administration, really no change in how they were being processed. It's just a matter of longer processing times.
My previous employer filed I-142 different times. First time the priority date is 10/18/2016. Second time it is 10/8. Which one is correct? You need to look into the labor certification to see when the labor certification was actually filed. If the labor certification was filed in October 8th, 2016, then that is a priority date. So just in case, by any chance, if the priority date is at 10/18/2016, based on the labor certifications, don't use the 2/10/8 though, because they may take your money and take the entire thing and still deny it. Question from Nikhilesh Mukhand. Compelling circumstances EAD. We have used it. We got the EADs for a lot of people, but we are not using it anymore. The reason is that compelling circumstances may not be that hard to achieve it. Compelling circumstances EAD is when you lose the job and you have an I-140 approval. When you're on H-1B, you can apply for compelling circumstances EAD, get a 1-year EAD depending on the circumstances. However, the minus point is that when you want to convert back into compelling circumstances to H-1B, previously we have the company to file a consular processing, get a H-1B, go to India, get the H-1B stamping, or go to Mexico or Canada and get the H-1B stamping and come back. Nowadays, that's not allowed because if the company is filing a consular processing, then the company has to pay $100,000 fees. We don't have many companies that we know of, or we don't have any company that we know of that came to us and tell Rahul, I want to pay $100,000 fees to my employee to file the H-1B. We don't have any. So definitely we have not used compelling circumstances since the time this $100,000 fees came in.
HHD says, is it possible to have 2 consecutive H-1B approvals and get no stamping on the passport for the first approval if I don't travel due to unavailability of stamping appointments? Absolutely. No issues at all with that. You only need a stamp on your passport if you are outside the US and want to get into the US. Once you're in the US, you don't need a stamp anymore. All you need is a valid I-94. The first one's going to be given to you by CBP. And you go online to get that after you enter the US. After that, your approval notices, your I-797 approvals will have a new I-94 attached to them. And as long as that is valid, you don't need a visa stamp if you're in the US.
Did you receive any selection notices for H-1B fiscal year 2027? Question from Tarak Panchal from X. No, not yet. Could it happen? We don't know. It could happen. Normally, we do receive in what time we receive, Emily, though?
We usually start seeing them the Thursday before the 31st. So I'm thinking 2 days from now in the afternoon is my guess. But they don't send the email notifications until the following Monday. So it's only if you log into your account and actually see them that we find them.
But as of now, we haven't noticed any selection process yet, guys. And as soon as we do, we will have a live session and inform you about it.
Yep. Well, I think we're out of time for today. Thanks everyone for joining. As usual, we'll be back next Tuesday with all the updates. Again, if you want more information about the Child Status Protection Act and how it can help your kids from aging out, join our webinar tomorrow. Otherwise, we'll see you back next Tuesday or whenever we have our next live to discuss the H-1B lottery results.
Where do they get the webinar link?
Go to rnlawgroup.com and you can find it in the blog section.
And
Or you can go to any of our social media.
we do have a daily Zoom conference call that's been going on from past 14 years. People can come and ask questions for half an hour. The timings are there. The link is provided at this link. You also can go to rnlawgroup.com. It's free. It's everybody can log in and ask questions. And thank you for tuning in. We'll see you next week.